Good morning, afternoon, evening, midnight, and noon. I'm William Espy with Precedent in Motion, and today we're going to be talking about one of the most important theories and doctrines in U.S. trial law, Daubert v. Merrell, or I guess the doctrine that came from Daubert v. Merrell. Today we're going to be going over the history of how the courts process and admitted scientific evidence, how this specific trial, Daubert v. Merrell, the case of Daubert v. Merrell, affected that, the background of Daubert v. Merrell itself, and how, after it was admitted as a doctrine, how it's changed over the years. Over the last 30 years or so, that's been a major doctrine within the United States. So, let's get right into it. Daubert v. Merrell, defining the admission of scientific evidence. Let's go to the precedent and legal backgrounds present in admitting scientific evidence in the United States. In 1923, the United States D.C. Court of Appeals presided over the case Frye v. United States. In this decision of that case, they said, quote, "The scientific method from which the deduction is made must be sufficiently established to have gained general acceptance in the particular field in which it belongs." Now, out of context, you don't really know what this statement is saying, but this statement is referring to scientific evidence, basically saying that if you want to admit scientific evidence in a court, you must have the general acceptance of a field of scientific study that the evidence is from. So, if you were to take, for example, in this case, a lie detector test, that lie detection test must have general acceptance in the scientific community as truthful and reliable in order for evidence of that to be put into court. That's basically what this is saying. Now, this would be fudged with a little 50 years later, in 1975. In 1975, Congress would pass the Rules Enabling Act. In the Rules Enabling Act, Rule 702 reads, quote, "If scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of opinion or otherwise." This is basically saying that if you have specialized knowledge or experience, you can testify in court as an expert witness. Now, this kind of goes at odds with the Frye standard, because, well, Rule 702 doesn't have any mention of Frye's general acceptance clause, which would kind of spell the end for Frye 20 years later. So, to get into that end, let's go into the background of the case that ended, Daubert v. Merrell. Joyce Daubert and Stacy Schuller were both pregnant women who took the drug Benedictine during their presidencies during the mid-1970s. Benedict itself is a drug made by the Merrell Dow Pharmaceuticals Company and advertised to reduce morning sickness that pregnant women have. Both women gave birth to boys, Jason and Eric, respectively, who both had serious birth defects at the time of their birth. In 1999, almost 10 years after both of their births, Joyce Daubert and Stacy Schuller sued Merrell Dow Pharmaceuticals in the U.S. District Court of Southern California for product liability, claiming that Benedictine caused the children's birth defects. So, you may ask, what were the proceedings in the lower courts? Well, I'll answer that question for you right here. See, the plaintiff argument was heavily based off testimony from animal studies, visual evidence, and reanalysis of, whatever that word is, data. All of which, however, did not really have any general consensus within the scientific community. As a result, Merrell Dow moved for summary judgment, seeing the opportunity, arguing that they couldn't prove causation if all the evidence was not up to the Frye's general acceptance standard. The court agreed, arguing that, well, summary judgment was the only real option here, and granted summary judgment for Merrell Dow. The plaintiff then appealed to the Ninth Circuit Court, who affirmed the lower court's decision. A little bit discouraged at this point, imaginably, they then appealed all the way up to the Supreme Court, petitioning under the issue of, quote, "Should the Frye's general acceptance test be the standard for admitting expert testimony in federal courts under Rule 702 of the Federal Rules of Evidence?" The Supreme Court accepted the petition and took up the case. Let's now go to the Supreme Court's decision. Now, the Supreme Court gave their opinion in the case, stating that, quote, "Frye made general acceptance the exclusive test for admitting expert scientific testimony. That austere standard, absent from and incompatible with the federal rules of evidence, should not be applied in federal trials. The rules, especially Rule 702, place appropriate limits on the admissibility of scientific evidence, but are not beholden to the general acceptance requirement. This opinion made it so that way the Fry's general acceptance standard was invalid in the federal courts, clearly as a result of its confrontation with Rule 702. Now, that wasn't all they said in this statement, however. They also said, quote, "The trial judge must ensure that any and all scientific evidence or evidence admitted that is not relevant but reliable." Now, this gave the burden of deciding the validity and relevance of trial evidence to the judge in that trial. They also gave 5 factors a judge can use to determine the validity and reliability of evidence. Starting off, number 1, is the method testable? Can you actually test it and see if the method actually works? Number 2, peer review publication. Has the method actually been shown to peers, and have they approved of the methods and outcome of the test? Number 3, error rates. Is there a potential rate of error in this test, and could the test actually be wrong? Number 4, standards. Are there any standards for the test? And number 5, general acceptance. Is the test or method generally accepted within the scientific community? Now, this notably is a factor of this, but not the overriding rule or standard that every single one must come to. The judges can use all 5 of these factors to determine the reliability and validity of a piece of scientific evidence. Finally, let's go into the impact of the decision and the changes that would be applied to the decision later on. First off, this decision implemented the new Daubert standard, marking a very, very big change for the admissibility of evidence in trials. It arguably raised the bar for what could be admitted as scientific evidence, and also made judges much more involved in deciding what would be valid or invalid, relevant or not relevant for scientific evidence. And it made them a gatekeeper, I guess you could say, of evidence. It also made the process for determining what was valid or invalid much more predictable. The courts now have a much more set in stone and grounded system to determine the validity of scientific evidence. There are also a lot of changes made down the road. Later on, Daubert was expanded on in General Electric Co. versus Jointer, which held that the appellate courts should refer to a lower court's decision on what evidence was valid or invalid, and Kumho Tire Co. versus Carmichael, which held that Daubert applies to all expert testimony, not just scientific expert testimony or regular scientific evidence. Additionally, a lot of state-level courts actually took up a version of Daubert into their own state-level court systems, although not always fully, and sometimes only taking a certain portion of it that they liked. That's all I have to say today. This has been Daubert v. Merrell, an analyzation of the history of Daubert, the effects of Daubert, and a background into the case itself. I hope you guys enjoyed. Once again, I'm William Espy with Precedent in Motion. Again, thank you guys for watching, and like I always say, good morning, afternoon, evening, midnight, good night. Thank you, and goodbye.